Moment of silence for the victims. Ladies and gentlemen of the jury, this is one of those cases that you wish you never had to produce. You wish that you never had to show anybody these kind of evils. You try to protect your children from these kind of evils, from seeing these kinds of things in the world. But I'm afraid that the only way to change it, the only way to make it better, is to confront it and to deal with it. Now, of course, in the last couple of videos, everybody's noticed I've been talking about the legislature. The legislature is what puts the government together. The legislature is the one with the real power, the real authority. But the executive branch, they're the ones that can cause real damage, real harm, real injury, real loss. So I go back to Pennsylvania, 1776. That all power being originally inherent in and consequently derived from the people. Therefore, all officers of government, whether legislative or executive, are their trustees and servants, and at all times accountable to them, to the people. And if you wish to have a true and lawful government, we have to get rid of sovereign immunity, qualified immunity, executive immunity, legislative immunity, sovereign immunity. These people, they don't even follow their own laws. With that being said, let me begin my presentation, my case that I present to you, the people of North Carolina. Because you already know about Greg Newman letting a rapist walk, somebody who raped a 12-year-old child. 12-year-old child. That's in Hendersonville. Some people are like, well, that's just one bad apple. It's just one bad apple. And I'm here to tell you it's not. It's not. And it's not going to change until you get that conviction in your heart. Roman citizens used to walk into a lion's den because they had that conviction about a man who hung on a cross. And we're letting kids get raped. WRAL, December 5th. No, my bad. WRAL 5, December 28, 2006. Maybe some of y'all remember, but in 2006 at Duke University, there was a rape. 3 white boys, as the media would call it, or 3 white males, raped a black woman who went to the school, UNC, with them. Don't you think it's kind of funny how the media and the government, they always like to classify us as white or black? Try to get us to fight amongst ourselves. Discrimination. They'll uphold that in their not courts of law. It's just to distract us from the true enemy. In a statement, the bar said it opened a case against Nifong. Nifong was the district attorney who was going after the 3 alleged rapists. On March 30th, Now, this is real important because they opened up their investigation on March 30th. Yet Nifong didn't even charge the first kid until April 17th. 2.5 weeks later, they opened up an investigation immediately on Nifong. You think that was political? I do. And it found on October 19th, so, roughly 6-7 months later, they finally found through their investigation that there was reasonable cause, not probable cause, reasonable cause to hand it over to the bar committee. Because we know how well they administer justice. I mean, they just let Greg Newman walk for letting another rapist walk. Duke University did release a statement Thursday evening reiterating President Richard Broadhead's call last week that Nifong turned the case over to an independent investigator. So here's a news article, and they're telling you that people are pressuring this district attorney, this prosecutor, to hand over his case. Let somebody else take care of that. You don't need to do your job on this one, man. Just sit this one out for the team. That's what they were telling Nifong. Last Friday, Nifong dropped the rape charges against the 3 athletes after the accuser, a North Carolina Central University student, told Nifong's investigators that she couldn't testify with certainty that she was raped, according to the dismissal motions. Okay, so you know me, I've done my research. I've looked into this case, and I'm going to give you my honest thoughts by the end of it. And I think what Nifong did with dropping the rape charges was a good thing. I think he should not have pursued the rape charges. I think he shouldn't have pursued the rape charges. Maybe against one of the individuals, but I'll get to that later. Anyways, the witness wasn't 100% reliable. This isn't a slam dunk case. Not a slam dunk case. Until the Bar Association got involved. So after Nifong's hearing, bar hearing, disciplinary hearing, they had their findings of facts. I still haven't seen the findings of facts and conclusions of law for Greg Newman, although they don't have any conclusions of law because they're not courts of law. Even in this case, all they have is findings of facts. They don't have any conclusions of law because what they're doing is not law. It's legal. It's legal. But just because it's not illegal doesn't mean it isn't criminal. Fact 46 that the State Bar found. Between April 7 and April 10, 2006, DSI, which was the DNA service provider, that was testing the DNA, performed testing and analysis of DNA found on the rape kit items. Between April 7 and April 10, DSI found DNA from up to 4 different males on several items of evidence from the rape kit and found that the male DNA on the rape kit was inconsistent with the profiles of the lacrosse team members. Now, this is going to be important later because what they're saying is the DNA that was found was completely inconsistent with the members on the lacrosse team, which 3 of them are accused and being charged with rape. Not at this point, but they were. Fact 47. During a meeting on April 10, 2006 among Nifong, 2 DPD, Durham Police Department, officers, and Dr. Brian Meehan, I don't know how to pronounce the last name, lab director for DSI, Dr. Meehan discussed with Nifong the results of the analysis performed by DSI to the point and explained that DSI had found DNA from up to 4 different males on several items of evidence from the rape kit, and that the DNA on the rape kit items was inconsistent with the profile of the lacrosse team members. All the DNA is inconsistent. They got 4 different pieces of DNA, but none of them match the suspects. You know, this sounds like an atrocity to justice. You know, this guy should be disbarred for a Brady violation. That's what they call him, a Brady violation. Fact 48. The evidence and information referred to above in paragraphs 46 and 47 was evidence or information which tended to negate the guilt of the lacrosse team members identified as suspects in the NTO. NTO is non-testimonial identification order. I don't know what their codes and things mean either, so I figured I'd help explain it to you. Fact 78. In response to the Duke defendant's June 19 discovery request and in response to Judge Stevens' direct inquiry, Nifong stated in open court that other than what was contained in DSI's written report, all of his communications with Dr. Meehan were privileged work product. Now, that's kind of crazy. So here, a district attorney is saying, even though we're talking about a case that has to do with the clients I'm charging, right, with the crime, our conversation is privileged. It's attorney-client confidentiality. You have no right to know what we were talking about in your case. Just to kind of show you how that system works. Nifong represented, he didn't present, he represented to Judge Stevens, and this is in quotes, that's pretty much correct, Your Honor. We received the reports which defense counsel has received, and we talked about how we would likely use that. And that's what we did. That's all we did. So, I just didn't like this case. It didn't smell right. So I had to do a lot of digging. You know me, I do my research. And I got the scientific report for the DNA. They mentioned multiple times it has nothing, no consistency with any of the lacrosse team members. Here's from a scientific evidence law journal. The probability of excluding a randomly selected individual from the mixture autosomal DNA profile is greater than 98%. David Evans cannot be excluded as a contributor to this mixture profile. A search of all possible Y chromosomes profiles within the mixture Y chromosome DNA in a database of 3,561 profiles found 14 matches. David Evans cannot be excluded as a contributor to the mixture. These results apparently led to Evans' indictment on May 15th, 2006. The DNA evidence directly led to his arrest, directly led to the district attorney, Mr. Nifong, going down, like he should properly do in the system we have now, but not in a real system of law, going down to a grand jury and getting a grand jury indictment against David Evans. Brad Banyan, one of Evans' attorneys, notice that, one of his attorneys, he took the whole report home and read most of it. I don't know how much he read, but it was an 1,800-page report. I'm sure it wasn't fun. He spent 60 to 100 hours on it. Now, David Evans should be really upset about this because he paid the attorney 60 to 100 hours and he doesn't know which one it is. Attorneys are really expensive by the hour, if you don't know. Anyways, I guess he wasn't that upset. About it. On October 27, Mr. Cooney, not Mr. Banyan, who was one of the attorneys, and this is in quotes, so he asked, and in order for Reed and Colin or David to have found these results of the test that excluded, they needed to go through those 6 inches of paper to find them. Is that correct? Dr. Meehan, that is correct. Mr. Cooney, because you hadn't put them in the report, is that fair? Dr. Meehan, that is fair. Now, here's what should be striking every American as odd. This doctor conspired with the prosecutor to withhold the evidence. And they didn't have any problem admitting to that on the stand. No action came about with it. And in fact, there were 2 police officers who were at the meeting on April 10th when the DNA was discussed. And they never told anybody. They never told anybody because the Bar Association didn't find reasonable cause until October 19th. Long way away from April 10th. This is how our system operates. So here's basically what Nifong did. He instructed Meehan to write the report, basically to just say that they had a positive confirmation. And that's what Meehan did. And the Bar Association took that as he was withholding exculpatory evidence and that the 2%, the 98% chance of likelihood that David Evans' DNA was found was absolutely nonsense. It was no chance. That's basically what the Bar Association found. It's disgusting. So let's continue on with the story, because when the Bar Association filed a complaint against Nifong, he had to write to the district attorney. When we were looking at Josh Stein's website for the district attorney, it says that he takes over cases when there's a conflict of interest with the district attorney's office. Well, there was a conflict of interest because of the bar grievance directly relating to this case. So Roy Cooper, the now governor, took over the case. He took over the case on, let me make sure I get my facts right, on January 12th. On January 12th of 2007. And then on April 11th, 3 months later, 3 months, he holds a press conference and he says that the boys are innocent. That all 3 boys are innocent. There's not even going to be a trial. We don't even get to see a jury. No O.J. Simpson in this case. Another silent moment for the victims. Nifong stated in a book that was written later that Roy Cooper would have done anything that would have given him some type of an advancement or was in his best interest. He would have lied and said that they were innocent. And it's not the prosecutor's job to declare the defendants innocent anyways. There was obviously enough evidence for a grand jury to indict them. There was obviously probable cause. Only a jury can determine that they're innocent after that point. Only a jury. So now we're going to listen to some of that press conference.
Now, the prosecuting witness in this case responded to our questions and offered information. She did want to move forward with the prosecution.
Okay. Right there. He just said he knew the victim wished to move forward with the prosecution. And he didn't ask for the victim's permission to dismiss it or get rid of it. That's the exact same thing Greg Newman did to the 12-year-old girl and her family. There's a pattern here.
We believe these three individuals are innocent of these charges.
Now, here is my absolute favorite part.
I don't want to say for sure whether Mr. Nifong talked with her before charges were brought. I know he talked to her at some point, but I don't know the answer to that question. We can find that out.
It's awful. So, Roy Cooper had this case from January 13th until April 11th when this press conference being held. He talks about how involved he was in this case. And it's because he's so involved that he knows these boys are innocent. And I don't know what the reporter just asked him. But what he said was he didn't know if Nangam, if the victim in this case, talked to Nifong before or after the indictments. How sure can you be about their innocence if you don't even know a simple fact like that after digging into the case for 3 months?
Our investigators who talk with her and the attorneys who talk with her over a period of time think that she may actually believe the many different stories that she has been telling. And in reviewing the whole history, there are records under seal that I'm not going to talk about, but we believe it's in the best interest of justice not to bring charges, and we have made that decision as well. Yes?
Obviously, news reporters were upset. They've been covering this story. News reporters were screaming for Roy Cooper to file charges against the victim. What are those charges for? False accusations. Thou shalt not bear false witness. It is a very serious crime to go into a court and report a crime that did not happen and accuse somebody of a crime that did not happen. Roy Cooper wouldn't do it. And he uses the fact that she has sealed medical records and sealed psychological reports, and that he believed that she believed she was telling the truth the whole time. You know what I think? I think he didn't want any fact about this case coming out in any court of law, anywhere, ever. I just don't know why. Because court was never held.
Well, what I've worked on is what has happened with this case. We've made a decision on this case.
Roy Cooper ends up ending it on the fact of how hard he worked on this case. The case that he still doesn't even know if Nifong talked to the victim before or after the indictments. And now, he's the governor. So you take Roy Cooper, Alexander Acosta, and Greg Newman. Well, they're not held accountable to law at all, but they either get to keep their job when they're incompetent or just blatantly breaking the law, or they get a promotion. This is sick. This is silly. And here is a PBS reporter talking about how Josh Stein worked under Roy Cooper when he was Attorney General.
Now, you worked under then Attorney General Roy Cooper, if I'm not mistaken, but becoming...
And Josh Stein has all but said he doesn't care that Greg Newman violated the law. He doesn't care that he broke the statutes of the state of North Carolina. But hey, you better not have pot, because they'll get you. You better not speed down the street, because, oh, you're going to get a fine. This is absolutely insane. And just to go along with the series of videos I've been making, this is exactly why you don't vote on the executive branch of government. Look at the chain of command. All the way from the governor, you got the governor of the state, the chief executive officer of the state. Then you have the attorney general, Josh Stein, Roy Cooper, Josh Stein. Then you have Greg Newman. Those are the only 3 executive branch offices that you can vote for, from the state capitol down to the county court. And they're all corrupt. They're all corrupt. This isn't a problem of 1 or 2 bad apples. It's a problem of bad government. It's a problem of bad government. And if the only way that we, the public, can hold them liable is at the voting booth, and they won't even allow us the common dignity to vote no confidence? And here's the biggest joke. Here's the biggest joke of all. In their own Constitution, in the North Carolina Constitution, Article 1, Section 2, it says, all government of right originates from the people, is founded upon their will only, and is instituted solely for the good of the whole. You know what they're telling you? They're telling you you're allowing this to happen because you're not stopping it. You're not using your will to stop those crimes. Just like all the other boys on the lacrosse team, it's called an accessory. It's called aiding and abetting. They all had a duty to help that woman. And I know some people will be judgmental and say that she was a stripper. She wasn't living the right life. She's even in prison right now for a murder she didn't commit. But some people might not see it that way. And here's all I gotta say. Does that justify taking away their rights to justice, to law, to right, just because of a few judgments of them? I don't think so. And what is this good of the whole that North Carolina's producing for the people? Because ever since I've started these YouTube videos, just half a month ago, I don't know how many different crimes I've reported that they've committed. I don't know how many times I've seen them abuse and hurt and inflict more pain on people than any type of law they uphold. But a snake's gonna be a snake. If you're serious about this, if you wish to see a change, be the change. If you wish to see a change, let the Creator change your heart. Be that Christian that walks up into the lion's den. Because you got conviction in a man hanging on a cross. I am just conspiracy, and I just wish to conspire with other good people of this planet to leave a better world for future generations than the world we all grew up in. Peace.